hit of it. So good. Oh, it says I'm live. Okay. Well, hello, time stuffers. Not enough hours in the day. It's past 10 o'clock. I've been making videos all day for all kind of stuff on TikTok and on YouTube's and on, well, actually not on YouTube, but on Facebook. Maybe some of that will get to YouTube's. But what am I doing? I'm reading the treatise on Persons by Brandon Joel Williams. So let's share screen. It worked out nicely last time. It totally did it like it was supposed to. Oops. Not that. This. Okay. So let's see here. I'm going to just do one tab, and the tab that I want to do is that one. I should be down there in the corner now. And I am. And we got a treatise on the word person. All right, so I got all the way through this. This is all kind of fun stuff here. Let's see here. The introduction, basically what he figured out, and he may be thinking that he's one of the first ones to figure it out, but he's not. You can find many videos from me where I say, we all niggas now, and that's what this made everyone right here. 14th Amendment. Yes, applied to Negroes. Yes, many have pointed this out, that there was a difference, and what they were trying to do was remedy a situation wherein the custom at the time was that, this was the other thing, and I made a note to myself in the other video underneath, is that that's a very English way of thinking about things, that the black man or the mulattoes or the ones with darker skin or the Indians or the mestizos were not equal, and you wouldn't have sex with them, you wouldn't breed with them except for very quietly, and if you did, like you're raping a woman or something, didn't matter because it's a Negro, right? It's a negress, and they're not even humans, so you can do what you want. Woke up and figured out that no, that's actually very poor thinking. So anyway, here we are at the word individual, and they helped wake me up because I realized that I didn't know what the word individual meant if Crouton Ramon was a living individual. But it turns out what that means is Crouton Ramon concern is basically, it's a business, it's a person that is not dead and not moribund and actually being used. The name is being used in commerce, therefore it's a living thing under the law, even though I made it up. Okay. And by the way, Crouton Ramon's House of Math is an organization, and organizations can have passports. Okay, now here's the problem. You get a passport for your organization, you're going to have to pay the fee. If you want a passport for the man or woman, you may be able to get a no-fee passport because you don't have to pay to exercise your rights, but you do have to pay for a passport. Let's start here. The beginning of the administrative state and replacing of the constitutional republic. Oh, there's so much I want to do because I need to make this whole other video. I had a meditation today that was mind-boggling, and I want to talk about that. And then I need to do some stuff with my boys who are far away in Laos, and all the other things that are going on with the math website, and oh my goodness. Anyway, I'm having a fun time. The beginning of the administrative state and replacing of the constitutional republic. What is a constitutor? Maybe you should look up the word constitutional and constitution, and then the word republic. See, because what they're trying to do is skirt around the constitutional republic and give us a democracy. And pretty much we have a democracy. Washington, D.C. and the United States Corporation is mostly a democracy. It's not a republic. It's a corporation designed on a democratic system. But that's not the government I was promised. What I was promised was a Republican form of government, a constitutional Republican form of government. But they'll give you a democracy if you let them. Okay, by the beginning of the 20th century, we see the beginning of everything that we see today. Every complicated body of law that they supposedly controls and specifies every area of the American existence. One more time. Okay, let's make this as easy as pie, as easy to understand as you can. Right? The only major issue with this is that they always use the word persons and never people, which assumes that everything they are writing is under the 14th Amendment, which has nothing to do with free white people who are citizens of the Union. He's not wrong. All right. The idea is that all the assumptions, you have to rebut the assumptions. And you don't rebut it. I have rebutted 13 of their presumptions. But one of the major presumptions, what are the major presumptions? And actually, you know what? I'm going to start early this time and go get a cup of tea. Is there? Oh no, there's tea in here. All right, I'm good. All right. Let's see here. Yeah, I'm just going to say it out loud. What the hell? Okay. What the DC Corporation has done is indentured, enslaved Americans, but they've done it voluntarily through the Americans' ignorance. From the beginning, that birth certificate, that's fraud. And I like it. I think it was April or June that was saying there is no such thing as civil fraud. Fraud is criminal. Fraud is a crime. And there's no statute of limitations on fraud, just like there's no statute of limitations on murder. You don't get away with murder just because some time passed. You don't get away with kidnapping just because some time passed. You don't get away with rape because some time passed. Capital offenses. There is none. There is no statute of limitations. Minor infractions and all kind of, violations of statute. Yeah, a lot of those things have. But see, that's all making up debts. The common law doesn't have any of that. The common law says that you have to harm somebody in order for and fraud harms every time. In fact, sometimes incompetence becomes fraud. All right. So what the hell happened? Did they begin to build an entirely new country, essentially on the heels of the 14th Amendment? Well, in my belief, that's what they did. They did exactly that. Every single mention or definition of U.S. citizen after 1873, there it is, the date. That's a date you should know. That's a date your homeschooling students should know. That's a date you know what happened in 1873. And those are the slaughterhouse cases. So it meant that every single mention or definition of a U.S. citizen after 1873, the slaughterhouse cases, meant an entirely new classification, which were citizens of the District of Columbia, which, keep in mind, prior to this point, anyone born in the District of Columbia had no right of citizenship of a state unless their parents specifically mentioned that they were citizens of a state, of the Union, and were not under the jurisdiction of the District of Columbia at the point of birth or conception. This is a complex situation, and now we sit here on our high horse thinking how things are or were, but we need to realize that at this time, they did not have the luxury of evaluating the information the way we are. Here we are, many years later, saying, oh yes, they understood. Well, we have our Chat GPT, Grok, Uber Eats, etc. This is something that we need to carefully take into consideration and understand that this fucking situation is not that goddamn simple. We are being ignorant, and we are not taking the time required to put ourselves into the shoes of our ancestors. We are nothing more than attempting to make sense of the confused people / persons that came before us. And see, I have a whole thing I got to do on first in line, first in time, that maxim. I have a friend who is a billionaire who took that maxim to the extreme, because first in line, first in time, which you are, you came ahead of the placenta, which is the thing that they named and numbered. But first in line for, okay, that also applies to, say, when you're in the trading pits, when you're doing commodities, whoever gets there first wins. He figured that out and has built an empire on that exceedingly simple concept. So what came first? The Republic came first. What came second? The person we call United States came second. All right, 10, the ultimate presumption. See, and this is the thing, the whole thing is based on presumption. So you have to rebut their presumptions, and you have to do it politely, right? Or cordially, we'll say. Doesn't necessarily, cordial doesn't necessarily include polite. But the idea is that you need to inform them that their presumptions regarding the person and the man may be in error. Now, here's the thing. They don't want to hear it. They straight up do not want to hear it. So, but you're going to tell them anyway. And so you're going to learn how to sign your name, slave. And see, what I've been censoring, it's basically the U.S. corporation enslaves Americans. Now, if you're a slave, one, they consider you a heathen. And in Leviticus, it tells you that they may enslave the heathens. Two, you can call yourself an employee. That's a serf. Go look it up. Go start doing some definitions of the word slave, serf, employee, etc. Now, if you're an employee, you don't own the corporation. You make someone who does own a corporation money. They pay you less than, and that's how it works, and you know that's how it works. If it costs them more to employ you than you put into the company, they're going to fire you, aren't they? You are going to be without a job because you have to be worth as a slave more than it costs them. All right. There's a problem there because there's a lot of slaves now that are getting old and they promise you, hey, you work for us all this time. And I'll tell you, we'll take some money and then we're going to match it. And then I'll tell you, and then you can retire. Oops, we don't have the money. I know we promised, but we had it, they don't always keep their promises, do they? So you work your whole life, and then what? Well, if you weren't a slave, you wouldn't have let somebody else handle your money. You would have had your own thing going on. You would have had your own trust. You would have had your own accounts that were not, quote unquote, bank accounts. But you didn't, and you don't. And you don't have trust set up, and you don't have metal, and you don't have, okay, so they tax your property, they tax you, they consider you they consider the name that you do business under theirs. They don't just consider it theirs, it is theirs, they created it. Doesn't matter if they created it fraudulently, this is the system we're under. So, and that's, I misspoke, because it doesn't matter, but it does matter. Because that's your ticket out, because it's fraud. So, and the contract is voidable because every contract you made up until the time you're 18 was voidable because they were made with a minor. And they gave you a 1-year grace period. They didn't tell you, but they gave you a 1-year grace period to fix your shit. And if you didn't fix your shit in that 1 year, well, now you got to do some other stuff. More paperwork. All right. So the ultimate presumption in Brandon Joe Williams' opinion. Personally, I believe that we follow a simple line of reasoning. We know everything, yet we dumb ourselves down and decrease our understanding in an effort to have something to do, something to learn, something to understand. I believe we are all capable of complete understanding, but we are bored. We do not like the idea of understanding everything or having a verbose clarity on things because that ruins it all. It ruins our ability to understand the current scene and relate to the current scene to what gives us excitement and clarity. Okay, I don't typically share my opinions on most things because it's essentially irrelevant. But I believe we are simply consciousness that are capable of creation and art, and we drift from body to body between lifetimes and experiences, and between lifetimes and experience amnesia due to shame and guilt. I realize this may be a bit extreme, but I'm just being transparent. He is not a Mason, he is a Scientologist. And again, a decorated Scientologist. So here is a little glimpse into the thinking of a Scientologist. So if this is true, then we are, and see, this is not just this one Scientologist. There are quite a few cultures that believe body comes, body goes. Right? You take nothing, you own nothing, and you take nothing with you. You don't even take the body with you. So this whole material thing, seeing right now, there is a saying, and it's not a joke. If they can't get you one way, they'll send a woman. And my sons are starting to understand the concept. Well, actually, they don't understand the concept quite yet, but the idea that a woman is part of the material world, and the sex with the woman becomes, and it goes the other way too, men. If you're a woman, they'll send a man. Because sex feels good, and it's part of the material world, and it'll lock you into this material world that much more. Anyway, and it makes you think you have a body, or it makes you think you are the body. You are not the body. And that little death that you have, as the French call it, the petite mort, that should let you know that you're not the body. Because for that little instant, you're not in your body. You're anywhere but your body. It starts in your body, but it certainly doesn't end there. Let's see. I don't typically. Let's continue on. Okay. So if this is true, then we are impossible to truly destroy. The true that what you are cannot be harmed by water or fire or wind. It can't be stabbed. It cannot be shot. It cannot be any of that. No fire burns you. It burns your body, but it can't burn you. It can't touch you. Now, if you know this kind of stuff, there's some great stories that, oh my goodness, I'm going to forget the man's name. I can see him clearly. Well, it'll come to me later. But he pointed out on more than one occasion that, yeah, this is the case. If that's the case, then why are you worried about going to hell when you die and being burned by fire? Because you can't, the thing that you are can't be burned by fire. And when you go to hell or heaven or whatever you believe in the afterlife, you don't take the body with. So why are you worried about fire and brimstone? Oh, come on. What was the guy's name? Oh, it's just escaping me at the moment. And could I find it easily? I'll tell you what, let me do a quick, just if I don't find it in one. Jordan Maxwell. There you go. Okay, so Jordan, our buddy Jordan, told you that he told numerous stories actually about the concept that he was talking to some priests as a young child, and he pissed them off because he used some very simple child common sense. But there it is. If this is true, then it's impossible to destroy. We're truly impossible to destroy. We can be changed. But anyway, this is his philosophy. Truly destroy, but we crave the illusion of oblivion because we want a high stakes game. And this is the whole thing. Holographic universe. That's where we are. I have a book. It's in storage on Maui. It pisses me off. I just saw it recently in a used bookstore. But the holographic universe. Pick that thing up and read it. The fact that we can describe this whole reality mathematically, down to the smallest detail, you can describe it with mathematics. That right there tells you you are in a simulation that was created using mathematics. Down to the most minute, and it fractals and scales holographically to the most insanely large, so huge that we can't even conceive of it, galaxies and so forth. But where we are, this plane, Midgard, not Asgard. You want to go to Asgard, but you're in Midgard. In Midgard, you have a body. You can't take your body to Asgard. Okay, but it's just a game. You're playing a game, and part of the game is waking up to the fact that there's others that are playing the game that are enslaving the masses. And what do? They call them employees. They give you money, a little bit of money. They don't give you money. They give you paper, but you can do anything you want with that paper, and they make as much of that paper as they want. And now they've taken a lot of paper that they've created out of thin air, literally out of thin air, not even bonded, not anything. They just have computers that they disclosed the fact that they were just printing money out of nothing. And then they use that money to buy silver and gold, platinum, land, organs. Anyway, okay. This is what we are unconsciously doing, in my opinion. Please don't attempt to argue with me on this. It's a waste of time. You're, like I said, he's a really, really high-level Scientologist. I guarantee you. I don't think he's read more than me, but the only reason why he hasn't read more than me, I will say that at that age, he has read more than me. When I was that age, I hadn't read as much as him, but I'm almost twice his age. So in that amount, and I read more than the average bear, and I read faster than the average bear. So to say that he's probably read more than me, no. He's read a lot of stuff that's different than me. He's read more, but I've read stuff that's different than him. And I've been playing this game. He's been playing for 4 years. I woke up. 57 years I spent a slave. And then I woke up. And then in the last 4 years, I educated myself more, and I am no longer fit to be a slave. Can't go back. This comes only with education. Part of this education is knowing what the fucking words mean. And that is this treatise that I'm reading now. And what are we talking about? Person. One word. And we can, because I'm certainly not going to do it. But actually, now with ChatGPT and a few agents and a little bit of time, and maybe it's not ChatGPT, maybe it's Meta, maybe it's Grok, maybe it's another one. We can write treatises like this for other words and go through and around and under and down rabbit holes and so forth, just with one word. Because person, that's one of them, but there's more. There's more than person. Anyway, this is what we are unconsciously doing, in my opinion, and please don't attempt to argue with me on this. It's a waste of time. You're entitled to your opinions, and we should honestly be more willing to talk about and have friendly debates on our opinions. That's how it's supposed to be, right? Your opinion and my opinion differ. And if it's in business or commerce, and we can't settle our differences of opinion, you go to court. And sometimes the court says, yep, you're right. You have irreconcilable differences. You can have this divorce. But you don't want a divorce. What you want, because that's still a contract with the state, what you want is annulment. This thing never happened. Okay. And then you go back. Well, assuming you want to stay married, technically, assuming you want to stay with the woman, then or the man, you go back and you annul the marriage, and then you come up with your own contract that does not involve a fictional entity like state of Arizona or state of Texas or state of Illinois. Because when you sign the marriage contract, or state of Washington or state of Idaho, I know some of the people who are watching from various places, or will be, or state of Montana, or state of Colorado, or state of Utah. You enter into a contract with that state, with that juristic entity. Especially when you go see one of their justices of the peace. you make a contract with the corporation. And guess what? They think that they own all of that. Everything that comes from that marriage, then, the produce, is theirs. And they make you inform on it by tricking you. Mom, especially, they don't really care about dad, but for sure, mom needs to sign that document. Unless mom is, of course, dead, and then there's other, right? But they want you to give them your children. That term, right? Not your sons and daughters. They want to convert your sons and daughters into children. They want to make you the pair that rents your children that you rent. Who are you renting them from? The state. They're giving you usufructs. You get to raise them. You get to send them to whatever school you want. You get to do whatever, but they get to bond them. And they get a claim on part of their income forever till they die. Get some Social Security, fuck you. You get to pay some tax on that too. You have any kind of property, slave, we're going to take a piece of that. Until such time as you wake the fuck up and do your paperwork. And even then, they're going to test you every step of the way after that. Really? You woke up, slave? Here's a contract. What are you going to do about it? Well, let's see. I may decide not to contract with you. Or perhaps I'll sign it now and then I'll rescission my signature later within 3 days. I don't feel like doing business with you after all. I have 72 hours. That is universal. And see, and then spend some time. You know who else did a similar thing to this? And look, I'm still stuck on 10 and hours are going by, or minutes are going by. But he read you, Brandon Joe Williams, the guy that wrote this, he fucking read you UCC 3 and made commentary on it. Right? You can sit there, lazy bones, don't have to read it yourself. You can put a pair of headphones on, close your eyes, and he'll fucking read you the UCC, right? And UCC 3, it's kind of an important one. That's where you know how to learn how to defend yourself in the venue of commerce. Actually, what I should say is under the merchant's tent, because all of our commerce is done under the merchant's tent. It's lawyers. The Lex Mercata. And it goes all the way back to Roman times. Anyway, excuse me. I ate just before we did this and slight indigestion. Okay, this is what we are unconsciously doing in my... keep on. Let's see. This is how the court should... Oh, wait. You are entitled to your opinion, and we should honestly be be more willing to talk about and have friendly debates about our opinions. Because some people, just because it's your opinion, doesn't make it right. But we have now this crazy thinking that opinions are sacrosanct. Okay, you can have the opinion that 2 squared is 9, but you're wrong. And see, what they're trying to say is that your opinion can never be wrong. Incorrect. Or your feelings that your feelings that come from those opinions or the other way around can't be wrong, because feelings, yes, they can. Anyway, this is how the court should be operating. It should be, and see what he found out? He found out the hard way. He thought that he was going to go into court talking sense with facts and figures, facts and evidence, and that the courts were going to listen. And his facts and evidence were based on what? The founding documents. I don't know, the Constitution. I don't know, all these statutes and the UCC, and their own documents. Right, their rules, the rules of civil procedure, and so on. And then he found out. And what about the Lex for the judges? Their own code of conduct and rules. I have now several people besides this, where they just basically wrote back and said, just like in the movies, those are more like guidelines, and we don't have to follow them. We don't have to be honorable if we don't want to. And we'll make up documents and backdate shit if we need to. We'll basically do whatever we want, slave. What are you going to do about it? So anyway, Brandon found out that if you you're not going to go in there and change things through the merchant's tent, because this is all administrative. You're not even in the judicial court of law. You're not in the third branch of government. You're not in the republic. You're in the U.S. corporation, Brandon. Anyway, this is how the courts should be operating. It should be a venue for us to have these conversations in a structured manner, following rules and such. That's not, he found out that's not how it works. And you had to find out the hard way, because you got to go in there and see. Because I thought the same. I thought that they were I thought one thing and it turned out to be another. But I also knew one of my best teachers was the adversary known to many of you as the Internal Revenue Service, but also paying attention in court and just do what they do. If they know they're going to lose, they don't show up, right? They'll concede. If they know they're going to win, they don't quit until they win. If they, well, there's a lot of other things, but the idea is they'll also do what's called, there's no other way to put it, subterfuge, where they try to get you to believe assumptions. And then based on those assumptions, and then they get you to try to hang yourself by you agreeing to some of these assumptions, not necessarily expressly, but you imply consent to some of these assumptions by your actions. Showing up to court, for example. We are walking a tightrope, meaning we want the mystery of the unknown without letting things fall into complete oblivion. I have no idea how this word person was so grossly lost in terms of meaning in general, especially in relation to that first line of the 14th Amendment. But here we are, and now it appears unbelievable that this is that this is the true source of all the issues in America. Well, he believes it clearly is. It's one, and it's one of the major ones. But the idea that there is so much confusion over the word persons, and they use that confusion against you, it should not be up for debate. And if it wasn't such a contentious and debated word and topic, we wouldn't be spending hours and hours, and it wouldn't have taken him, right? He wouldn't have written this many words regarding this one word. Anyway, the ultimate presumption is that you are a Negro. And that presumption is solidified by you answering yes to questions like being a U.S. citizen or a resident. Negroes released by the 13th Amendment and given a special citizenship through the 14th Amendment are always either a U.S. citizen or a resident when it comes to one of the 50 states of the Union. I have news for Hawaiians. If you consider yourself, or if you've told them that you are a native Hawaiian, you better go look the definitions of native Hawaiian, because a native Hawaiian is a U.S. citizen. And if you told them that you're a native Hawaiian that resides in the state of Hawaii resides in Washington, D.C., it operates in this territory known as the Hawaiian Islands. Not the islands of Hawaii, by the way, the Hawaiian Islands. I used to live on an island called Maui Island. And for the longest time, I thought it was County of Maui and Maui County were the same thing, and it turns out not. And there's actually documents that some people have dug up to prove the fact. Again, they hide nothing. But the ultimate presumption is that you are a Negro. Are you a Negro? I am not even a Negro. I descend from some that may have been considered Negroes, but I've been mulatto for my whole life. My sons are not even mulatto because, well, technically they are, because they're half and half from half and half. But the idea that you're a Negro when you're Irish or Scot or English or Brit or Indian, or Spanish, or see, and then I didn't get to that. The Spanish didn't look on the Negro or the dark skinned the same way the British did. In fact, if you take a look at Mexico and all the part of the Spanish Empire that conquered in the Americas, they absolutely took the women. Right? They took Indians. They took anyway, and anywhere they went actually, because there are a lot of half black Spaniards, and then same thing Muslims, right? The when it comes to Morocco and the Moors, and then the same thing with the Moorish culture. The Moorish culture didn't have an issue breeding or having children with the heathens or the others, because they knew that when you put the soul in that body, then you just educate the soul and you bring them up. They can be whiter than white, and you've seen it in the United States, where they have very fair skin, but they talk black, they act black, they listen to quote unquote black music. And the same thing in Spain. There are Spaniards who are black, but they speak Spanish. They are Spaniards, but their skin is dark. On the other hand, there are Moroccans who are fair skinned. I've seen Turks you wouldn't know. Same thing. Anyway, the idea being is that you educate the mind, and that makes the man, not the color of his skin. See, and they figured this out too. Is that, oh, we just stick a guy in there that kind of looks like one of them. We'll call him Barack, and they'll think they're one of him. The thing that inhabits Barack is not like you and me. The thing that inhabits a lot of those guys, it's a whole different thing, but they have the shell. And see, they know that we look at the shell. And so they use the shell to classify you. But here, the presumption is that you are a Negro under the 14th. And what you've done is sign your name repeatedly. Yep, I'm a Negro. Yep, I'm a U.S. person. Yep, I want to vote. Yep, I want that loan. Yep, oh, I want that driver's license. Yep. Oh, got to have that bank account. Yep. Oh, I got this car loan because I couldn't afford to buy it with cash, so I got a car loan. And right there on the car loan, it says, "Are you a U.S. person?" And you said yes, or it said, "Are you a U.S. citizen?" And it said, and you said yes, and then you signed your name to it. So how they gonna know that you're not a U.S. citizen when you have told them repeatedly? When I was 57, I can't even count the number of times that I told them that I was a U.S. citizen, fraudulently, out of ignorance. But at the same time, that's my signature, and it says U.S. person. So now I got to rescind all of that. One fell swoop, you can do it. Now, if you would have done it when you were between the ages of 18 and 19, oh, they realize this is the whole. And then, see, you're going to find out. 5-star passport, yeah, that's the beginning of the journey. That's not the end of the journey. Anyway. And see, this is what he says next. Anyway, and the presumption is solidified by you answering yes to a question like being a U.S. citizen or a resident. Negroes released by the 13th Amendment were given special citizenship through the 14th Amendment and are always either a U.S. citizen or a resident when it comes to one of the 50 states of the Union, unless you declare otherwise. Your right to self-determination is recognized by United States Corporation. And that is the International Covenant for Civil and Political Rights. It's right there. The United States Corporation is a signatory. And the first thing it says is you the one going to determine who the fuck you are. They're not going to tell you. But they may trick you into telling them what they want to hear. And what they want to hear is that you are a U.S. citizen, therefore giving them plenary power over the name, therefore making you absolutely subject to the United States Congress. By your own volition, you sign the document. Nobody made you sign the document. You're the one decided you needed to drive, because you didn't know the difference between traveling, you didn't know what commerce was, and you didn't understand the Commerce Clause, and nobody ever taught you. Because certainly they're not going to give you the information to get out from under a system that extracts wealth from you, especially when a lot of you think that you should be having the wealth extracted, that it's your duty to pay it to the pirates. Okay, so you the one when sign. However, and they laugh too, because there's a lot of people in the government, no idea what this is talking about. If they read this would be but there was a lot of people in the government, particularly wearing black dresses, that absolutely know exactly this, and they are trained to trick you into saying what they want to hear. Starting with, will the defendant please rise? And you do. Starting with when they call your name, that ain't your name. But you think it's your name, so you say that's your name, and when they call out that name, you say, yeah, and there you go. You don't make any qualifying statements, you don't object. Okay, being a U.S. citizen or resident, and we got to talk about this. See, that's a whole other video. Anyway, being a U.S. citizen or a resident means that you are not really an American, right? Americans, we're crazy. We believe we have unalienable, and inalienable rights that were given to us by God Almighty. Not by a constitution, not by a bunch of fuckheads in Washington, D.C., not by a guy in a funny hat in Rome, not by a guy in a funny hat in England or Spain or anywhere else. None of the men in funny hats gave me my rights. Okay, so being a U.S. citizen or a resident means you are not really an American within what you think that classification is composed of. It is impossible to be a U.S. citizen, resident, and an American at the same time. You want to be a fucking radical. Take the nose ring out and be an American. You must be willing to choose one or the other. And for some of you, U.S. citizen is where you want to be. There are rights and privileges, but just understand that those rights and privileges can be taken away. Because they're rights and privileges that were given to you, afforded to you by a corporation, by a person that was designed and created to engage in the most peculiar institution. That's the whole thing. The peculiar institution is alive and well. Every person you've walked by in the mall that's tending a store is a slave. Unless they own the store. And even then, they're still probably a slave to the corporation. Because why? They're going to give away more than half their money. Back in the day, the worst tyrant, King John, would only take 10%. Now they're taking 38 and 15, and by the time you total it all up with property tax and tax and sales tax and your automobile tax and your property tax and your all that other tax that you put, the income tax, federal and state, and sales tax, and okay, they take half. And then what? Then they charge you for your electricity. Then they charge you for water, slave. I'm so old, I remember when the water was free and you could drink it right out of the tap. Crazy motherfuckers. You want water that you can drink out of the tap? Fuck you, we're giving it to Ukraine. Oh, no, wait, we're not giving it to Ukraine anymore. We're going to give it to Israel. I think $50 billion would put pristine water in Flint, fucking Michigan. I think $50 billion would take the chemicals that were spilled into the water supply in Ohio out of the water supply in Ohio and make that water perfectly drinkable for infants. $50 billion, 1,000 million, 50 fucking times. And the average U.S. citizen bends over and asks to take it harder. Meantime, they can drink the water out of the tap. You may have lost track of what's important, people. Just saying, maybe. Or maybe I'm just crazy talk. But anyway, the slaves are starting to wake up, and this has got them very concerned. So they're going to try and put you back to sleep, promise. And most of you will. But see, some of us, you can't, once you wake up, you can't go back. You can't go back. You fucking can't go back. You have to kill me first. And even then, I'm not coming back like that. See, because next time I come back, hopefully my sons don't fuck up and the grandchildren are also free. And I know they won't fuck up. But see, all the information that I'm giving you here, they already have. They already knew about the fact that that 14th Amendment made them into Negroes, which they are not. They didn't need Brandon to tell them that. I told them that. And I figured that out many moons ago. But there are many things that I hadn't figured out that Brandon did. And there are many things I figured out that Brandon still hasn't figured out. I can tell by some of the things that he says. But they'll teach it to him. Okay. I'll just read this last paragraph quickly and then we'll be on to 11. Being a U.S. citizen or a resident means that you are not really an American within what you think that classification is composed of. It is impossible to be a U.S. citizen, resident, and an American at the same time. You must willingly choose one or the other. I would argue the point that you can be both. But if you're the man, see, now is the thing. You'll be the man is going to be the American, and the allegiance or the thing that you put in front of you is the U.S. citizen. Crouton Ramon is not going to be a U.S. citizen. It's going to be an American citizen that I made up, and is going to have a trust in an organization that is outside and foreign to Washington, D.C., the United States Corporation. It's not going to be part of the United States Corporation. It's not going to be licensed by the United States Corporation. It's going to be recognized by the United States Corporation as its own entity, a trust. And there is international trust law. And then there is American trust law, wherein the lawyers have figured out how to get into your trust. And there's ways around that go beyond the scope of this lesson, because right now we're talking about persons. But anyway, you must willingly choose one of the others, and since you are not technically forced to choose either one, your choice is to forego your American roots and decide to classify yourself as a Negro, a U.S. citizen. And that choice is considered voluntary. They never force you. They did. They tricked you, but in their mind, they didn't do anything wrong. You're the one that signed it. They didn't sign it for you. People are simply choosing not to be true Americans without knowing what they are doing. This is the entire conversation. You've been fooled. Mommy was fooled. She filled out some stuff on a piece of paper that she had no business filling out. Hey, can you do me a favor? Bring me some tea. My liberal tears have run dry. You got to shake the jaw a little bit, though, because I put spirulina in there. Well, actually, no, I didn't put spirulina. I put moringa. I'm going to put a little moringa powder in my mate. All right, we are up to the incorporation doctrine. We are at 11. Only 5 more to go. And if I shut up, this won't take as long. From the jar in the fridge. Thank you. The incorporation doctrine. The Cornell... Oh, that was you. Okay. The Cornell Law page, where I will be pulling most of the information for this section, can be found at Cornell. And you should make a donation to, and there it is. You see it, right? The corporations... okay. Throughout the years... throughout the years later after the Slaughterhouse case, we have what is called the incorporation doctrine. This is essentially where they are trying to build back in one original. Okay, start over. Okay, the incorporation doctrine. This is another one, and spend time on the incorporation doctrine. This is essentially where they were trying to build back all the original rights that were for white state citizens back into the U.S. citizen category. Cornell law describes it like this. The incorporation doctrine is a constitutional doctrine through which parts of the first 10 amendments of the United States Constitution, known as the Bill of Rights, thank you, are made applicable to the states through the due process clause of the 14th Amendment. So they were trying to fix them up, and they just wound up making it worse by adding more paperwork and more things for them. And see, there's a body of thought that says they did this on purpose because the only time they make money is when you go in there and argue. They want contention. They want you to have differences of opinions that you pay them to settle. Okay, there shouldn't be there. We should have a Republican form of government, period. No argument, right? So then there's this stuff called stare decisis. Anyway, I'll shut up and get back to this. The incorporation doctrine is a constitutional doctrine through which parts of the first 10 amendments to the United States Constitution, known as the Bill of Rights, are made applicable to the states through the due process clause of the 14th Amendment. You should know what the due process clause of the 14th Amendment is. We'll get to that later, actually. Prior to the doctrines and the 14th Amendment's existence, the Supreme Court found the Bill of Rights to only apply to the federal government and to federal court cases. During the signing of the Constitution, every state, did you get that? During the signing of the Constitution, every state in the negotiation had different levels of concerns with a too powerful federal government, which is the Federalists turn out to be 100% correct because the federal government usurped everything. But anyway, and the preamble to the Bill of Rights highlights the importance of the Bill of Rights in limiting overreach in the newly created government. See, these documents were supposed to tie them down, not tie us down. Would stop them from making any fucking law that had anything to do with religion. Right? They should have put the same verbiage in for the Second Amendment. You can't make any fucking law with regard to my right to bear arms. Not your job. Not your job to tell me what God to worship. Not your fucking job to tell me how to stay healthy. Okay, the Supreme Court noted that in the Bill of Rights, the Supreme Court noted that the Bill of Rights was clearly intended to limit only the federal government. See Barron v. City of Baltimore, 1833. States, you notice the capital S, and state courts, notice the lowercase s, should choose to adopt similar laws, but we are under no obligation to do so. Right? They're not obligated. That's another thing. Obligation. There's a whole other treatise. Because your rights come with obligations. You don't get to just do what the hell you want. After the passage of the 14th Amendment, the Supreme Court, through a string of cases, found that the due process clause of the 14th Amendment included applying parts of the Bill of Rights to states, referred to as an incorporation. A lot of contention surrounds whether the 14th Amendment should incorporate any substantive rights, with opinions from Supreme Court justices ranging from complete to no incorporation. So in other words, complete incorporation or no incorporation at all. And they make distinction, by the way. If you look in the law, you look in a lot of the statutes. I almost called this statutes law. The statutes are, and it's a stretch to call the statutes law, but they'll call it law every day. Anyway, rather than find that the due process clause incorporates all of the Bill of Rights, the Supreme Court supported selectively incorporating rights that the court finds are essential to due process. Under the selective incorporation, the Supreme Court incorporated certain parts of certain amendments rather than incorporating the entire amendment at once. Why would they do that? So right there, they're kind of sort of telling you there's a difference between that Constitution for United States and Constitution of United States, and there's kind of a difference between the persons and the people. Anyway, some argue that the Privileges or Immunities Clause is a more appropriate textual basis than the Due Process Clause for incorporation of the Bill of Rights, but because slaughterhouse cases dealing with this clause are surrounded by controversy, this theory is not supported by the majority of the court. So some guys decided. As a note, the Ninth Amendment and the 10th Amendment have not been incorporated. Which is why they tell you that you are not. See, it all starts to make sense. Because there's other places that you can read where 1 through 8, do not apply. But 9 and 10, why do they not apply? Because those are incorporated. And the two that don't apply, the 9th and the 10th, have not been incorporated. And it is unlikely that they ever will be. What does the 9th say? What do the 10th say? Oh, therein you find rights. Many of those rights delineated in the 5th USC, 5 USC, but spread out all over the place from 1 to 50. Anyway, the text of the 10th Amendment directly interacts with state law, and the Supreme Court rarely relies upon the 9th Amendment when deciding cases. What do the 9th say again? As you can see, the above is a clear and excellent description of what this is. All right, here we go. You should know these. Here is a copy of the past breakdown of each of the originally 10 rights that the white man had and their corresponding cases which incorporated or deemed them unable to be incorporated the original state citizen rights into the privileges and immunities available for the Negroes in the 14th Amendment. The 9th and 10th Amendments were never incorporated, so only 8 remain. First Amendment, fully incorporated. Guarantee against the establishment of religion. Right? Free exercise of religion. Freedom of speech, freedom of the press, right of assembly and petition, freedom of expression and freedom of expressive association. Even though not directly mentioned in the amendment, where the court states that the implicit in the right to engage in activities protected by the First Amendment is a corresponding right to associate with others in pursuit of a wide variety of political, social, economic, educational, and religious and cultural ends. So that's basically freedom of association, right? Expressive association. You got to be able to be free to get together with other people and have the same opinions and express them. Anyway, that's Roberts v. United States JC's. The other ones, the guarantee against establishment of religion, that's Everson versus the Board of Education. Free exercise of religion, Hamilton versus Regents of the University of California. Freedom of speech. This is actually a really good resource right here. Freedom of speech, Gitlow v. New York. Freedom of the press, Near v. Minnesota. Right of assembly and petition, Dijon versus Oregon. Okay, Second Amendment, fully incorporated. Right to keep and bear arms, McDonald v. Chicago. That's it. See, and we got the Hawaii Supreme.
Oh, aloha, Ben, because aloha, you guys know can defend yourself. We're not going to let you, because aloha, you guys know still have guns. If you guys have guns, that's not aloha. People with aloha, they don't have guns.
Third Amendment, not incorporated. let's see here. And, Third Amendment, we're not too worried about troops, except for the fact that we're paying for troops. They don't house them anymore. We pay to house them on military bases. But we weren't supposed to have standing armies. Also, would you say that the FBI is a standing army? Would you say that the ATF is a standing army? Would you say that the CIA is a standing army? Would you say, you get the point? Your local police force looks like a standing army to me. A lot of them are replete with military weapons, body armor, military vehicles, fully automatic weapons. And then they tell us, we can have fully automatic weapons, but you can't have. And besides, you don't need a fully automatic weapon. We use them, but not you guys. And Americans, okay. There was a time when I could order a Thompson fucking machine gun out of a catalog and have it delivered to my door. That time was not long ago. Okay, Fourth Amendment, fully incorporated. Freedom of unreasonable search and seizure. Map v. Ohio. They got around that on the roads, didn't they? Requirements in a warrant. Aguilar v. Texas. Fifth Amendment, partially incorporated. The right to indictments or a grand jury. It's not incorporated. That would be Hurtado v. California. I should have had an indictment or a grand jury. I have never seen an indictment nor a grand jury for anything. Okay, double jeopardy. Ooh, I seem to know about a case where the thing was thrown out with prejudice, and yet they brought it a second time. That would be Fifth Amendment, right? Right against double jeopardy. That would be Benton v. Maryland. Right against self-incrimination. That would be Mallory v. Hogan. That was 1964. The double jeopardy was 1969. The right to indictment by grand jury since fucking 1884. This is my favorite thing, showing fucking sheriffs and other guys. Oh, that's an old law. So what? Like, oh, the Constitution, that's an old law too. It still applies. You want to point out some other old laws that I don't have to obey? Dumb motherfuckers. Protection against taking property without due compensation. Chicago, Burlington, and Quincy Railroad. Right? Wait a minute. Chicago, Burlington, and Quincy Railroad Company versus City of Chicago. Because the City of Chicago was trying to pull some fucking hanky-panky eminent domain against some of the railroad companies, and they weren't having it. I'm going to go read the case. Sixth Amendment, partially incorporated. Right to speedy trial. Klopfer v. North Carolina. Right to a public trial. Let's see, that would be all in Reed Oliver, right? What is that? 333? Interesting. Right to impartial jury. Parker v. Gladden. Right to notice of accusations. Like, what are you accusing me of? You got to know what they're, right? And I find out, it took me a long time, but I found out that I was a fugitive of justice. Really? I was a fugitive of justice. Okay. Can you prove that I was a fugitive? What did I do to become a fugitive of justice? The right of notice of accusation. I just did that. The right to confront hostile witnesses. I look whoever you are in the face. If you're accusing me of something, I get to confront you. They try to get around that too, because sometimes, and I have to agree, when it's been a very violent crime, the victim may not want to confront anyway, or be confronted by the person that they're accusing. Anyway, right to confront hostile witnesses. That's Pointer v. Texas. Like I said, this is a hugely important. When you're writing your documents, you can cite these. right? And you're going to write them in your own words, and you're not looking for a template from the fucking 100th Monkey. You're not looking for a template from Brandon Joe Williams. You're not looking for a template from Yusuf L. You're not looking for a template from April to June. You're not looking for a template from fucking, and you better not use a template from Anna von Reitz or David Straight. Pick up your fucking pen, learn some words and some grammar and some law, and write your own damn documents. And if you can't, well, gee, you're probably not in line for sovereignty, personal sovereignty. And maybe, just maybe, you'd rather be a U.S. citizen. I prefer not to be. I don't want any fucking thing to do with that corporation. I'm at peace with that corporation. And the document that it pretends that we're reading from right here, I absolutely agree with. I will defend and support and protect the United States Constitution. No, I won't. The United States Constitution, that's the corporation's constitution. The one I like is the Constitution for the United States of America. Because this corporate constitution that Brendan's talking about here, and the word person, that's where we get the 14th Amendment. Go back to the Constitution for United States of America, and those amendments are a little different. But be that as it may, let's see here. The right to confront favorable witnesses, not just hostile ones. That is Washington v. Texas. The right to counsel, Gideon v. Wainwright. You can use that one to your advantage. Because I have the right to counsel, but the, what is it? Public Defender's Office of the County of Maui has a conflict of interest with me. So they will not represent me. So they had to go get an outside lawyer. What the hell was the lawyer's name? Oh, she's going to sleep. She brought me tea though, so I'm happy. Okay. But you're right. It's getting late. Fuck, we're running on going toward midnight already. Okay. The right to compulsory process to obtain witnesses' testimony. Oh, that would be depositions. Let's see here. That would be Washington v. Texas. Right to confront favorable. I just did that. Right to counsel. Just did that. Right to jury selected from residents of the state and district where the crime occurred. By the way, that's not incorporated. Seventh Amendment, not incorporated. Eighth Amendment, fully incorporated. Protection against excessive bail. Protection against excessive fine. All right. Oh, wait. Excessive bail. Schlib v. Kubel. Protection against excessive fine. Timms v. Indiana. Protection against cruel and unusual punishment. Robinson v. California. There is also another case I wanted to show you that describes many of these rights being converted into privileges. So they're no longer rights. They're like, well, we can give them to you if we want to, if you earn them. It's a privilege. And then added in on the U.S. citizen side of the equation. Oh, wait. There is also another case I wanted to show you that describes many of these rights being converted into privileges and then added in on the U.S. citizen side of the equation. Twining v. New Jersey. The case was later overturned in Mallory v. Hogan. We just talked about that a second ago, in 1964. But this case is still wildly important because it breaks down the historical timeline of all the various cases and things that happened up to 1908, involving all this information about the differences between U.S. citizens and state citizens. This quote is talking about what rights U.S. citizens have versus state citizens. Some of this information is outdated and should be compared to the above incorporation doctrine cases for reference. Let's hear what the Honorable Justice William Henry Moody a man with 3 names has to say, in this case, my son has 4 names. I have 3 names, but both of my sons have 4 names, and there are others that have 5 and 6 names. But I thought 4 was too many as it is. Anyway, 3 is probably better, but usually it's at least 3. And then there are others that only have 2, and then there are some they only have 1. Anyway, thus, among the rights and privileges of national citizenship recognized by this court are the right to pass freely from state to state. Let's read that again. There's some people on Maui, if they're watching this, you guys should be nervous as fuck. Fraud, kidnapping, violation of right after right, trespass, criminal trespass, under color of law, RICO. Oh my God, the list is so long. Anyway, thus, among the rights and privileges of national citizenship recognized by this court are the right to pass freely from state to state. I don't know, like from Hawaii to Arizona, for example, with my property and my property rights. Let me see, that's Crandall v. Nevada. The right to petition Congress for a redress of grievances. Many people have tried to petition Congress for a redress of grievances, and they found out that that's complete bullshit, but it looks good on paper. United States versus Cruikshank, and the right to vote for national officers, ex parte Yarborough, the right to enter into the public lands, United States v. Waddell, to be protected against violence while in the lawful custody of a United States Marshal, Logan v. United States, and the right to inform the United States authorities of violations of its laws. And that's in re Quarles. The right to trial by jury in civil cases guaranteed by the 7th Amendment. Walker v. Savant. Oh, wait, is it Salvenet or Salvenet, depending on how French they are. And the right to bear arms guaranteed by the 2nd Amendment. Presser v. Illinois. Presser v. Illinois needs to be taken over to the state of Hawaii and shown to Supreme Court justices in the state of Hawaii. But anyway, it won't make a difference. But let's see, have been distinctly held not to be privileges and immunities of the citizens of the United States guaranteed by the 14th Amendment against abridgment by the states. And in effect, the same decision was made in respect to the guarantee against prosecution except by indictment of a grand jury contained in the 5th Amendment in Hurtado v. California. In respect to the right to be confronted with witnesses contained in the 6th Amendment, which is West v. Louisiana. So let's not get lost in the concept that they were doing their best to put all of those rights and privileges into the citizenship of that 14th Amendment citizen and then wrap everyone in the same cloth. It's kind of like the Republic. It's kind of like the United States of America Constitution, sort of. So this is essentially the world we have been living in, and our self-proclaimed persons, Negroes, under the 14th Amendment. And these various rights have been incorporated into the 14th Amendment. But there's a problem. We all are pretty aware about how the world actually works. And this is often where these various incorporated rights don't work like you think they should, like you would think they should. There you go. Well, that's quite simple. And the Honorable Justice Taney already told us why previously in Dred Scott. Again, I will use bold and underlines to bring your attention to specific areas in the quote. So pray, pay attention, this one over here, this one over here. And then, of course, this part right here, underlined. Okay, the question before us is whether the class of persons described in the plea in abatement, we read this once before in the other video, right? The question before us is whether, hold on a second. Pardon me. Okay. The question before us is whether the class of persons described in the plea in abatement compose a portion of the people, right? Are the persons part of the people? And are constituent members of this sovereignty, right? Is that the case? Are persons people? We think they are not. Oops. We think they are not. And that they are not included and are not intended to be included under the word citizens in the Constitution. Oops. I should read that like a normal person. Should not be, they were not intended to be included under the word citizens in the Constitution and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of United States. You see the words United States of America there? On the contrary, they were at that time considered to be subordinate and an inferior class of beings who had been subjugated by the dominant race and, whether emancipated or not, yet remained subject to their authority, and had no rights or privileges but such as those who held the power and the government might choose to grant them. So you can see above, these incorporated rights are not really rights. Yeah. So the ones that are unincorporated, okay. So are you catching on here? So 9 and 10. What do 9 and 10 say? Those are unincorporated. What do 3 say? That also unincorporated. So as you can see above, these incorporated rights are not really rights. They are exactly what they say they are: privileges and immunities under the 14th Amendment. So are you asking for privileges and immunities under an amendment that doesn't apply to you? If you're one of the white folk, you might be. Privileges and immunities can be taken away whenever they want. I think do you see the emphasis there? I've mentioned this also myself. If they can give them to you, they can take them away. Here is the definition of privilege: a special right, advantage, or immunity granted or available only to a particular person or group. This was made crystal clear in the case in 1968, United States v. Valentine. Yeah, let's see, that was down there in Puerto Rico, District Court D, Puerto Rico, where the Honorable Chief Judge Hiram R. Canicio, or would that, yeah, I'm going to say Canicio, said, the only absolute and unqualified right of citizenship is to residence within the territorial boundaries of the United States. A citizen cannot be either deported or denied re-entry. Bingo. That is exactly correct. U.S. citizens, meaning Negroes, have only one right. They have many privileges and immunities, but only one single guaranteed right and no others. What's that one guaranteed right? So if you have yourself classified, wait a minute. So if you have yourself classified as a U.S. citizen or a resident or a permanent resident of a state, the information in this section carefully breaks down your situation. This may shed quite a bit of light as to why this country is the way it is. I imagine now it's starting to make a lot more sense. The government is essentially asking you all the time, are you a Negro? Right? Are you a Negro? And you are saying, yes, I am a Negro. Look, I'll even sign my name. Here, I'll sign it. Here, have that. That's me. I'm a Negro. I'm a 14th Amendment citizen. I'm a U.S. citizen. Yep, U.S. citizen. That's me. I'm gonna sign it again. Yeah, I want a bank account. Yep, I want driver's license. Yep, I want state ID. Yep, I want water bill. Yep, I want electric bill. Yep. And that's what's so shocking. is that no one on either side of that question actually understood the question. Everyone is ignorant. We are in an unthinking nightmare. A permanent resident is simply someone who has had their citizenship, meaning allegiance or subjugation, elsewhere and has decided to stay here in a foreign land without becoming a state citizen. As a resident, your citizenship is not defined in that term. It is simply known that your citizenship is not in that area. It is simply assumed by the term that your allegiance and subjugation lies elsewhere. What's amazing is literally all of this chaos and insanity was caused due to one single misunderstood word, the word person, the first section of the 14th Amendment. And it's too wild to even believe in Brandon's. See, that's why I'm old and jaded. Like I said, this seems to be new information to Brandon, and it's not. Anyway, it's like he got a new car, except it was a 79 Plymouth. So it was new to him. Anyway, 12. XII. Using anything derived from the 14th Amendment automatically makes you a Negro. Bing, 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 bing. Let me repeat that because it's vaguely important. Using anything derived from the 14th Amendment automatically makes you a Negro. So what makes this so complex is that in court, the basic fundamental equation for almost anything going on is like this: duty, breach, damages. Notice how he connects those with dashes. Brandon, every time you use all caps, you need to use those dashes. So even that title right there, 12, using anything, there should be dashes between all of those. Otherwise, just like when they give you documents that you assume you can read, that says using anything derived from the 14th Amendment automatically makes you a Negro. You put the dashes in there, and then it says using anything derived from the 14th Amendment automatically makes you a Negro. Other than that, that's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 words, even though there's no periods. It's just 12 words. You stick the words together into a sentence by either making them lowercase or putting dashes there. And then you need to use some rules of grammar with regard to person, place, or thing, because certain words are going to be capitalized. Grammar is not a game, and it is the game they play with you to make sure that they beat you. In law, this is called a cause of action. A cause of action is essentially the basic breakdown of a specific claim or a complaint. What caused you to take action? Right? They were censoring me on Facebook, and I have free speech rights. That's my cause of action for suing them. Oh, wait a minute. You can't sue them for violating your free speech rights because they have a contract that says that they're allowed to. For example, a cause of action for breach of contract would be they had a duty to perform based off contractual obligation. The contract is then attached to the claim or complaint as evidence or as an exhibit. See, facts and evidence, exhibits or facts and evidence. Now, here's the thing: affidavits, facts or evidence? Testimony. Can you bring testimony into court? Right? Okay. They don't want oral testimony. They don't want audio testimony. They don't want recorded testimony. They take testimony on a document. And then you have to take that document and you put your testimony, right? An affidavit, testimony in the form of an affidavit. There's a difference between just a regular affidavit and testimony in the form of an affidavit, because testimony in the form of an affidavit is evidence and can be exhibited. Notice my use of language. Someone breached that claim, ideally with an attached evidence proving the alleged breach. Damage occurred due to this breach with attached evidence affidavits proving the damage that resulted. This, in essence, is the composure of a cause of action, and then one or more causes of action may comprise a complaint. Nobody like a complainer. Learn how to press claims. It's really quite simple. There's the issue. If you use anything as a cause of action which comes from the 14th Amendment, you are, in essence, classifying yourself as a Negro by doing so. Whoa, gotcha. I'll give you an excellent example. Let's take a look at at 42 U.S. Code, Chapter 21, entitled Civil Rights, which is another way of saying privileges and immunities, because they're civil rights. They're not unalienable rights. You can see how obvious this situation is in 42 U.S.C. 1981A. I will use underline to show you the key parts. Okay, all persons within the jurisdiction of the United States shall have the same rights in every state and territory to make and enforce contracts, to sue, be parties, give evidence, and to the full and equal benefit of all laws and proceedings for the security of persons and property, as is enjoyed by white citizens, and shall be subject to like punishment, pains, penalties, taxes, license, and exactions of every kind, and to no other. And in 42 U.S.C. 1982, that's kind of an important one, we see the following wording, where again, I will underline and bring your attention to an area. You know what he's bringing your attention to. All citizens of the United States shall have the same right in every state and territory as enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey real and personal property. Notice the difference between real property and personal property. One implies a loyal title, and the other implies anything that's real estate, real ID, real is not real. That's how you know, because they're liars, and it's the opposite. Now, all this is highly important because two of the most common statutes in civil cases when their rights are violated, for example, against police misbehavior, are 42 U.S.C. 1983 and 42 U.S.C. 1985, which are right after the above 42 U.S.C. 1981 and 42 U.S.C. 1982. Obviously. Okay, so everyone bringing claims or causes of action under 42 U.S.C. 1983 or 42 U.S.C. 1985 are using the Negro's Civil Rights Code. So thus, obviously, the presumptions will be that you must be a Negro, and this is the issue. You never know, right? And the idea is that the Negro was subject to Congress and those in Washington, D.C., not you and me. Now, keep in mind that the government did give you a sole proprietorship, which is simply just your name in all caps, and that is the persons, notice the S, that actually is a 14th Amendment U.S. citizen. You can prove that easily because when you look up who can get a Social Security number in 20 CFR 422-104, you will see that you need to be a U.S. citizen, that would be Negro or a legal fiction, in order to have one. So have you got a Social Security number? You're a Negro. or at least a juristic entity, a legal fiction. Because when you get down to it, it's all mind. It's the first Hermetic principle. So you have a U.S. citizen called a sole proprietorship, right? You have the thing. Do you own it? Is it you? Is it the same as you? Right? I have a body. I don't own a body, and I am not the body, but I have one. I don't even know how the thing works. Get right down to it. How does this? I don't have any idea. Right now, I know I'm probably digesting some tea because I've been drinking it. There's all kind of minerals and vitamins, and I put moringa in here and some honey and so on to make it delicious and because liberal tears are delicious. They are delicious. But at the same time, the liberal tears that I'm drinking are doing something in here, and my body takes it, and then my kidneys do something, and some of it comes back out, and some of it apparently goes into my lymphs. I have no idea. I just do this part. My body does the rest without me thinking about it. Anyway, it's highly important. Let's go back here. Let's see here. So you have a U.S. citizen called a sole proprietorship, which is under the 14th Amendment. And this is exactly how you can bring a claim under 42 U.S.C. 1983 or 42 U.S.C. 1985. But you, as a free white man, state citizen, actual American, absolutely may not do so. See, and that's what they were trying to trick me into doing, is filing something under 42 USC or any of the USC. Because if you're using the United States Code, you must be a Negro. But you are a free white man, state citizen, actual American, absolutely may not do so. Okay, so how would you navigate something like that? Easy. Just make your sole proprietorship. Wait a minute. Easy. Just make your sole proprietorship as a person the plaintiff in the lawsuit, and you become the attorney in fact or the next friend on behalf of that person, or you can be the agent for that person. Anyway, in this way, you can still bring your claims without committing a felony by saying that you are a Negro when you are not. Which can put you in prison for up to 3 years, according to 18 USC 911. Yeah, but no. If you prefer to actually bring a claim yourself without some kind of persona or corporate fiction as a white state citizen, I would recommend that you use your original state's constitution in state court or use the original Bill of Rights in federal court. Besides that, with anything else, you would need to check it to see if it is derived from the 14th Amendment. Do you see what he's getting at here? You don't want anything to do with the 14th Amendment. Newsflash, almost every area of law is derived from the 14th Amendment. Oops. If you see the term persons anywhere, and it's fucking everywhere, and you see man and woman nowhere, then you immediately know you are looking at something derived from the 14th Amendment, speaking about Negroes and corporate fictions exclusively. 13, qualified immunity. Here we go. Qualified immunity and the true source of systematic racism in America. One more time, bro. You can put all caps, put the dashes. Preface to this section. I truly believe that only a small percentage of the police force are intrinsically persons of ill intent. Legally, police officers are persons, not people. By the way, I'm not just saying that. That's an actual legal fact. That's absolutely true. Cops are persons. Like, police officers are persons. But I do believe that the overall policing system is currently operating in a way that needs some serious adjustment. We just need to tweak the system, and all the police officer will adjust to the way that the system is adjusted. So the police are not the enemy. It's simply the calibration of the system itself. I'm also not excusing police brutality, but there is a middle ground, and that needs to be acknowledged. I agree there needs to be some police because there are bad men out there. And there are also evil men out there. But guess what? They've infiltrated a lot of the police forces. But he's correct. This system could change quite a bit, and we could remove the police from being police and put them into sheriffs and deputize these men and have a completely different system. But we're not gonna. But anyway, there's ways to fix this. We just choose not to. And then he also leaves out the lodges and all of that. So this is lying by omission, Brandon. Okay, so let's talk about the qualified immunity. First, let's get a definition and start the section off with an article from National Conference of State Legislatures, NCSL, that I think is a great starting place. And, oh, look, he puts the website in there and everything. Oh, wait, and I bet you I can click it and it'll show right up. And unless it shows up on the same page. Nope, it showed up on a different page, so it won't show up here. Anyway, it's lovely, and it's a little thing about qualified immunity. And see, Trump wants to give them even more qualified immunity than they already have. We're going to qualify it more. Anyway, the doctrine of qualified immunity protects state and local officials, including law enforcement officers, from individual liability unless the official violated a clearly established constitutional right. I don't know, like traveling from state to state with. Anyway, the evolution of qualified immunity began in 1871 when Congress adopted 42 U.S.C. 1983, which makes government employees and officials personally liable for money damages if they because the state doesn't want to pay this. So what they do is they'll bond and so forth, but the state doesn't want to be responsible for the actions of the dumbass. So what they do is, which makes government employees and officials personally liable for the money damages if they violate a person's federal constitutional rights. State and local police officers may be sued under 1983. Until the 1960s, few 1983 lawsuits were successfully brought. In 1967, the court recognized qualified immunity as a defense to 1983 claims. In 1982, the Supreme Court adopted the current test for the doctrine. Qualified immunity is generally available if the law a government official violated isn't clearly established. Now, at this point in the conversation, you already know where I'm headed with this. All of this applies only, right? What's that say in big letters? All of this applies only and exclusively to Negroes. If you already saw that coming, great. It means you're starting to learn, thank Christ. Now, this gets more interesting because we can see this even more clearly by actually diving into the cases associated with this situation. Let's take a peek, shall we? We shall. I'm not much of an AI guy, but I've recently been using Grok to find cases to dig into specific subjects. I typed into Grok, what main court cases established qualified immunity for the police? And this is what it gave me. So see, he used AI to help write this. I'm telling you, AI is going to change everything. AI changes everything. And there's going to be a whole lot less lawyers. There's going to be a whole lot less coders. There's going to be a whole lot less. And then you know what's coming? Robots is coming. There's going to be, it won't be long before a man can have a robot for, I don't know, 10 grand. look like a woman, talk like a woman, walk like a woman, clean house, do dishes, have sex, but it's a robot. That's not. That's no longer decades away. That's no longer some far out. It's coming like a bat out of hell. I was just reading the first fully equipped, anatomically correct female robot, reasonably looking. It still looks like a robot mannequin live thing, but it's amazing, and that's changing in just a little while. And they're doing this intermediate step to get people used to it. But anyway, $175,000. Yours? All right, let's look at these. Pearson v. Ray in 1967. This was the first case to recognize qualified immunity as a defense for public officials, including police officers. The court held that officers could be shielded from liability for constitutional violations if they acted in good faith, without clear knowledge that their actions were unlawful. So, if you inform the officer that the actions that he's taking are unlawful ahead of time, they cannot claim qualified immunity because you told them that what they were doing is unlawful and they did it anyway. But what are you going to do about it, Slade? You're going to press a claim or you're going to complain?
He violated my rights.
Harlow v. Fitzgerald, 1982. This case refined the doctrine by establishing an objective standard for qualified immunity. The court ruled that officials are immune unless their conduct violates clearly established constitutional rights that a reasonable person would have known, removing the subject good faith requirements. Or subjective good faith requirements. So, in other words, a reasonable person should have known that it was right. Anderson v. Creighton, 1987. This case further clarified that for a right to be clearly established, prior court decisions must have defined the right with sufficient specificity. It protected officers unless their actions were clearly prohibited by existing precedent. Saucier v. Katz, that's 2001. The court formalized a two-step test for qualified immunity. Step 1, whether the officer's conduct violated a constitutional right, and 2, whether the right was clearly established at the time. This rigid sequence was later made flexible in Pearson v. Callahan in 2009. And then there's Mullenix v. Luna. This case emphasized the high bar for overcoming qualified immunity, reinforcing that a right must be defined with particular. Wow, there's a word I haven't seen in a long time. Particularity, not a general level, to be considered clearly established. Oh, particularity. Oh, wow, this guy's using some English words like that, eh? Okay. Now, at this point, most of you dumb fucks would start asking Grok more questions and to summarize the cases for you and all other manner of worthless, pathetic bullshit. This is how we got into the situation in the first fucking. Oops, he didn't put fuck there. This is how we got into the situation in the first place. Obviously, no, he put it there instead. Obviously, no one fucking knows this shit about any. Wait a minute. Obviously, no one fucking knows shit about any of this. Otherwise, we wouldn't have the fucked up situation we have. So don't be a worthless jackoff. Use AI to locate cases, then actually take the time to go read them. Don't ask AI, which is an amalgamation of other persons' misunderstandings and retardations. What these cases say. Yeah, don't be asking other. Right, and that's the other thing. It's Grok, and it's some of the AIs will straight up lie to you. Okay, so take a deep breath. Let's head over to the Google Scholar and look up the Pearson v. Ray out of 1967. Light up a cigar and take a look at what quotes we can dig out of that thing. Okay. These cases present issues involving liability of local police officers and judges under Section 1 of the Civil Rights Act of 1871. Ooh, going way back. Let's see here. Stat 13, 17 Stat 13, now 42 USC at 1983. Oh, see, there's a nice piece of information. So 17 Stat 13 is now 42 USC 1983. Petitioners, that's another thing. The whole pedigree and the evolution of statutes, where they came from. Like you'll see that there's a whole bunch of statutes that all they are is the UCC. Anyway, petitioners in number 79 were members of a group of 15 white and Negro Episcopal clergymen who attempted to use segregated facilities in an interstate bus terminal in Jackson, Mississippi in 1961. Oh. All right, so wait, stop right there. Stop the train. You mean to tell me that the most basic case establishing qualified immunity is a motherfucking case involving the arrest of Negroes attempting to use segregated facilities at a motherfucking bus terminal? How are people not absolutely pissed about this in 2025? How is this a reality? Please tell me, where are the liberals on this one? Where is literally anyone with two fucking brain cells to rub together? How has this not been overturned or challenged all these years? See him finding out a whole bunch of stuff. I can tell you, part of the reason why I grew up in Hawaii is because back in 1964, might have been 65, my mother took me into a whites only bathroom. Ooh, they spit in her hair. Okay, my mother